Be ready. 5 seconds. Start. These appeals are against a judgment and order dated 21st November 2017 passed by the High Court of Punjab and Haryana at Chandigarh, allowing the criminal revisional application being criminal revision petition number 849 of 2016 filed by the respondent accused challenging a judgment and order dated 20th February 2016 passed by the additional sessions judge Palwal in criminal appeal number 13 of 2015 filed by the respondent accused inter alia affirming a judgment and order of conviction of the respondent accused passed by the judicial magistrate first class Palwal under section 138 of the Negotiable Instruments Act 1881 stop. It is the case of the appellant complainant that the respondent accused issued a check being check number 034212 dated 4 March 2012 drawn on Axis Bank branch Palwal in the name of the appellant towards repayment of a friendly loan of rupees 15 lakhs advanced by the appellant complainant to the respondent accused stop. On 11 April 2012, the appellant complainant deposited the said check in his bank, but the check was returned unpaid with the endorsement insufficient fund stop. The appellant complainant has alleged that on the assurance of the respondent accused that there would be sufficient funds in his bank account to cover the amount of the check, the appellant complainant again presented the check to his bank on 23rd May 2012, but it was again returned unpaid with the remark insufficient fund para. On 15 June 2012, the appellant complainant issued a legal notice to the respondent accused through his lawyer calling upon the respondent accused to pay the check amount stop. The said notice sent by registered post was, according to the appellant complainant, duly served on the respondent accused stop. The respondent accused, however, did not reply to the notice stop, nor did he pay the check amount to the appellant complainant stop. The appellant complainant filed a criminal complaint against the respondent accused, being case number 106 of 2012, before the judicial magistrate first class Palwal under section 138 of the Negotiable Instruments Act stop. Sections 138 and 139 of the Negotiable Instruments Act are set out herein below for convenience stop. Dishonor of check for insufficiency etc. of funds in the account where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank, such person shall be deemed to have committed an offence and shall, without prejudice to any other provisions of this act, be punished with imprisonment for a term which may be extended to 2 years, or with fine which may extend to twice the amount of the check, or with both. Stop. The object of section 138 of the Negotiable Instruments Act is to infuse credibility to negotiable instruments, including checks, and to encourage and promote the use of negotiable instruments, including checks, in financial transactions. Stop. The penal provision of section 138 of the Negotiable Instruments Act is intended to be a deterrent to callous issuance of negotiable instruments such as checks without serious intention to honor the promise implicit in the issuance of the same. Stop.